Off to another episode in this special series, Can the Records Be Trusted? With me today, Dagmar Hovestädt, one of 3 female researchers behind this special series. Today we approach the subject of records that belong to everyone, and therefore it appears sometimes hard for anyone to see them. These are the records of an international organization, the United Nations. And we approach this through the perspective of records collection within an active UN mechanism documenting human rights violations in an ongoing conflict. So today I welcome Robert Petit, the head of the IIIM, a UN mechanism whose full name I will leave to Robert to spell out. So what is the IIIM and what does it do?
Thank you and good morning, and thank you for having me. The IIIM, which stands for International, Impartial and Independent Mechanism for the Syrian Arab Republic, was created by the General Assembly. There was a resolution of the General Assembly in December 2016, in light of the atrocities that were being committed and are still committed in the Syrian Arab Republic since the popular uprising of March 2011, and the lack of accountability for those atrocities. There were several attempts, 17 I think in all, to try to refer the situation to the ICC and the Security Council. All of these attempts were vetoed by Russia or China, and there was obviously no proceedings, no pathway to accountability in Syria. So the General Assembly created in a completely novel way this mechanism, whose mandate is to collect, consolidate, preserve, and analyze information, evidence concerning the commission in Syria from March 2011 of international core crimes, genocide, war crimes, crimes against humanity, and to use that evidence to support future and current jurisdictions in accountability for those crimes.
Do you have access in the country to record violations?
We have asked, and we do ask every year, to engage the Syrian Arab Republic and any other parties that we deem potentially have relevant evidence. We have not had any response yet.
So in essence, it's a mechanism that is created to produce records, right? So what is, in terms of recording what happened and preserve the evidence or the records that you created? So what do you document exactly and how do you preserve it or keep it?
Yeah, I'll clarify.
Yeah.
At the time that the mechanism was created, the Secretary General referred to it in his report as a quasi-prosecutorial office. So we don't have any jurisdictions to issue warrants or to prosecute or try anyone. What we do is we use criminal law standards, which already differs us from any other types of organization collecting this type. So we use criminal law standards to collect, consolidate, and preserve information from other sources and from our own, generating our own evidence, witness statements mostly. And we analyze this evidence to support jurisdictions who are conducting criminal investigation or prosecution or trials of persons responsible for these crimes. So in essence, we work, as I said, as a quasi-prosecutorial body, collecting from sources, mostly civil society actors, but also international organization, multinational organization, the UN itself, any bodies that we believe could be a source, that's what we call them, a source, of information regarding those crimes. We collect it, as I said, using these specific standards, not to document IHL violations, but to support criminal prosecution of core international crimes. That's something that differs us, for example, from the Commission of Inquiry, which does document mass violation of IHL. We are supporting criminal prosecution.
That means the documents you gather are copies that go through your process. And in terms of witness, obviously this is original material that you create, but you never create it to keep it for yourself. You keep it to support other legal bodies in their efforts to prosecute.
That's a very good question, because one of our core mandate is to preserve that information. So we created a repository, and since the mandate of the IIIM is open-ended, that repository, we established it with a vision of a long-term relevance and use and preservation. So that information we collect, as I said, from sources, and we also produce reports, analytical reports, legal reports based on that evidence, or we generate our own evidence, mostly witness statements. So we either collect from a source, something physical, or a statement from a source, or we go out purposely to support, for example, our lines of inquiries. We have 3 lines of inquiries. So we go out and generate evidence, mostly in the form of witness statements.
So all of this is digital information that you put in a repository under certain safety precautions?
It can be evidence that is initially digitized, yes. It can be evidence that we then digitize, or it can be evidence for which we have a digital record, such as a photo of a site, let's say. In terms of collecting, consolidating, and preserving, we have established protocols, information management procedures that we had to develop in a bespoke way in some ways, given the specific nature and the novel nature of our mandate, that allows us to preserve and be able to establish the authenticity of the material we hold, and to also help us make determination about the authenticity of the material itself. So there's a long process and different procedures for this, either on the side of information management itself or either on the side of authentication and reliability.
So that when somebody accesses your repository, there is some sort of a seal of approval, chain of custody, value of the evidence by the mere fact that it's coming from the IIIM?
Yeah, well, first, nobody accesses our repository, obviously. We access it on behalf of jurisdictions. So essentially right now, what we are focusing is supporting jurisdictions. So ongoing proceedings in 16 different jurisdictions so far have forwarded to us 408 requests for assistance, numbering over 210, I believe, distinct separate investigations. So they ask us for information, we provide them with information.
So is that universal jurisdiction in individual countries?
Yes. Yeah. And also including the International Court of Justice, which Canada and the Netherlands are parties with Syria in front of the International Court of Justice by virtue of the Convention Against Torture, to which Syria and obviously the Netherlands and Canada are parties. So that evidence, as I said, we preserve in two ways. First, in terms of the collection itself and the preservation of it. And then in terms of its reliability, authenticity, we have, of course, established protocols. In terms, we may proactively or upon one of those RFAs, share specific information or specific records. For example, if a jurisdiction asks us, do you have information about Mr. X? We will look through our repository and find everything that we find relevant for Mr. X, and then share it with the jurisdictions without any evaluation as to its credibility or authenticity or reliability, and leave that to the jurisdictions to evaluate within the whole of their case, right? There's oftentimes best place to do that. It may happen that then a jurisdiction will ask us, okay, could you please validate any the authenticity or the reliability or the credibility of that material? Then we could do that for a specific piece of record, let's say. On the other hand, what we do and do a lot is produce analytical or legal reports. They can be, for instance, and was at the beginning of the IIIM, for instance, we produced a legal report, on the elements necessary to establish the date of the international nature of the conflict in Syria, which, of course, for a national jurisdiction that has never done anything like this, was a very useful element. We have also produced a very topical report. We've produced, among other things, a report on the use of the Syrian detention regime as a tool of oppression. It's a very extensive report, over 200 pages of it, which my predecessor decided that the proceedings in front of the ICJ were of a sufficient nature, really, even though it's not a criminal proceeding, but were of a sufficient nature that would establish the commission of core international crimes, that she made the decision to share that report on a confidential basis with the Netherlands and Canada, which of course will then eventually make its way into the record of the court. So that report, for example, any sources that we used in that report, that is the basis for an assertion from us, okay, those documents, those records, anything that we use, we will then make sure to authenticate its reliability and its credibility. So there are various processes by which we can do that. Obviously, most of them are good old-fashioned, tried and true.
So when you say you use tried and true methods, what exactly is that in terms of your analysis and then authenticating the evidence you bring into the analysis?
But fake evidence or unreliable evidence is nothing new. right? And again, my focus is criminal proceedings. So ultimately, the goal is the highest level of reliability and credibility, right? Beyond a reasonable doubt, or serving the basis to achieve beyond a reasonable doubt. So basically, when we're talking about large amount of data that we do, first of all, we really verify the source, right? If we have any reason to believe that material would be fake or unreliable, so we really authenticate the source.
So is the source satellite imagery? Is it OSINT? Is it,
in our lingo, source is an entity that holds records. So it could be OPCW, or it can be the White Helmets, or it can be a person. So for us, a source is a source of information, of records. So we check that source out to make sure we don't have any legitimate concern.
But open source, like an uploaded video, could be also
open source is a different matter.
Okay, but that's not something you look at.
No, absolutely. We do collect open source, and we're actually very good at it. And again, we've developed some methods that have been now replicated in other UN entities in various parts of our information management system. Reliability of open source, of course. We're also very good at capturing quickly open source material. We all know the Syrian conflict was probably, has been said to be the most well-documented conflict in history. Everybody had a cell phone, and everybody was watching, the atrocities being committed and filmed and uploaded right away. So we knew, of course, going in that this was going to be a big part of our line of business, if you like. So we got the personnel and we got the technology, and then retooled the technology to suit our aims. Because it's one thing to have an information management system that's made to handle 5 million email in a fraud lawsuit, to managing millions of videos about atrocities. So we took some of those solutions, and as I said, rejigged them for our own purposes, and some of these have been then duplicated in other entities. But in terms of the open source, first we will try and make sure that material looks like what it is, that it looks relevant to what it is. And then we'll do a source evaluation as much as we can. We'll try and authenticate the material. We'll try and corroborate the material, or what it purports to depict. And we'll run technical tests to see that the material itself has not been manipulated in any way. We'll use what I can say is state-of-the-art technologies that we can use, or if the material itself is the records are too much, then we'll contract with very high level entities that can do that for us.
So the analysis that you create, I'm curious if you're allowed to talk about it. So when did the war in Syria start, based on your analysis there, or can you not talk about it?
No. Well, the conflict clearly started in March 2011. Right, when there was a popular opposition that started as a political protest, seeking political reform, and then the brutal repression that followed. And then, of course, numerous actors then followed, some of which were internationals. And we believe that in 2012, the conflict was internationalized, if I'm not mistaken. But I will get back to you on that.
Yeah. So, but these types of information, the analysis, are not publicly available. They're only there to support judicial mechanisms, right?
Yeah, exactly. We are not, for example, that's a big difference with the Commission of Inquiry. They are mandated to publish report. We don't, as a rule, publish reports. We are a quasi-prosecutor office that supports criminal proceedings. So obviously the notion of confidentiality is essential and central to our mandate and the way we conduct it.
Does the mechanism have a long-term idea of what will happen to the records if the mechanism is concluded and maybe there is, a Syria that is able to deal with its own past in a different way than today?
That's a very interesting question, and one that's preoccupied me actually in all the posts that I've held, because so what those records do, they support a finding of truth about what happened, right? And if you're talking about a transitional justice process where a society is rebuilding after a conflict, that judgment, that finding of truth about what happened should be and can be the starting block from which everything else flows. It's a small part of a much bigger process. We have to be humble about what we do, judges and prosecutors and everybody in that courtroom. It's a very small part of a much bigger process. But it's an essential part because then everybody can start from the same baseline. This is what happened, to whom, for why, by whom, when, and how. Given that, you can rebuild something based on the truth. So the archives and the access to that archives, to me, is unfortunately, it's a fundamentally important question that we only grasp too late. And when I say we, I mean us involved in this. These international criminal law processes from the beginning. Now I know and I understand that as soon as you set up one of these mechanisms, you should have a few things from the get-go completely right. Witness protection, of course, outreach, of course, and closure from the beginning, and put that in place and throughout the life of the institution. So in terms of our institution, as I said, our mechanism, our mandate is open-ended. We don't have an end date. So the resolution for the IIIM gets voted every year by the General Assembly to overwhelming support, which I'm hoping will continue. But in any event, eventually, yes, we will transition out to something. Ideally, and that brings me to the last, one of the also most important thing about our mandate. Ideally, if Syria sets up a transitional process that meets international standards, then yes, the archives could indeed be a central part of that process. I say international standards because we are mandated to assist competent jurisdiction. The interpretation of competent jurisdictions mean jurisdictions that apply international human rights standards and processes to their criminal proceedings. So that's why from certain jurisdictions we cannot entertain requests for assistance. Provided that Syria, in theory, would set up these types of tribunal, not only, yes, would, of course, the archives be an essential part of it, because we aim to be, as I said, the repository, and we are actually now the repository for a lot of the information regarding the Syrian conflict. So it flows that that repository should be a central part of allowing this process to take place. That's provided, of course, that the archive is properly set up. Now, it's not a matter of just preserving things. An archive is a different matter. It's a preserved record that can be used for the intended user. So 20 years from now, we need to plan, and we are planning, and we will be planning, whenever we transition into something else or cease existing, that processes are in place clearly on how to maintain reliable access to that data for whoever needs to in the future. But it is my hope that this would be a national process, national-led process, because much like hybrid courts, of which I'm now a firm believer on, I think they are essential. It's essential to have an engagement from the stakeholders, the national entity itself, and people in these processes to have any credibility and chance of success.
Do you think that this strict idea of collecting data with a mindset of a lawyer for legal proceedings limits the data or makes them stronger? And what are particular challenges then? I mean, I can picture a huge amount of data that goes through all these processes, these standards. You continue collecting this maybe for another decade or more, and out comes a huge digital archive that is always with the intention of being used in proceedings, but there's a lot more that's documented, and there's a lot more purposes that this documentation could be used for. So it needs to get wide open, including all the limitations that come from privacy issues and so forth. So is that something that goes into the collection now and in the storage and in the way you manage the data that you collect?
Oh, of course. But the first criteria is this material relevant, right? So obviously any lawyer will interpret this as widely as possible, right? So we collect evidence relevant to the commission of these court and national crimes this year in our republic since March 2011. And that material could indeed be used for all sorts of processes that not strictly criminal. And again, it does not mean that it's restricted in any way, because if you're talking about relevant evidence to what happened, then yeah, you'll have a broad range of issues that that material could be useful for.
Yeah. Let me ask you as a final question, something that goes a little bit to a meta perspective, and I want to make sure I get this right. You were involved in judicial proceedings after some of the most atrocious crimes and human rights violations on a worldwide scale. You were an international co-prosecutor in the IIIC in Cambodia and a senior trial attorney at the Special Court for Sierra Leone, as well as part of the UN mission in East Timor. So is there, when you look at all of the evidence or the proceedings that you were in, is there a common thread in relation to records that you can see if you can zoom out and look at all of this from above the mountain?
Well, yeah, and actually I started with the ICTR, the Tribunal for Rwanda, in 1996. So since then, obviously, the scene has changed tremendously.
From paper to digital.
Yes, digital. Yes, very much so. If I remember the ICTR back in 96, it was very, very analog. But one of the marked changes has been the involvement of civil documenters, right? Organized civil documenters for these crimes. That has led, obviously, to a proliferation of evidence, of records, I should say, not necessarily evidence, of records that one has to sift through and use all these processes that we've established, this information management protocols, to make sure that it's done the right way. But even in ICTR, we had, and of course, you also have to think about these specific crimes require specific elements, right? And it also depends which type of perpetrators you're going after. A direct perpetrator, you might not need that much of contextual in it, but you still need, for example, to establish if it's a crime against humanity or a war crime or genocide, you need contextual elements, chapeau elements, to which additional material than simply a witness statement said, yes, he did this, or I saw him do this. So you'll have a much use of records, various records. If you're talking about chain of command or authority cases, then yes, you have to use a lot more different types of records. But all these records, as I said, are multiplied because of these actors now in the field. So on one hand, I think, obviously, it has opened up a whole slew of possible source of evidence for us, for these processes. But at the same time, it has generated tremendous needs in terms of resources, both financial, technological, and also personnel. So you need people who are experts at different types of things to be able to tell to you lawyers, yes, this is useful, this is why, and this can be trusted. And then us dumb lawyers have to be able to translate that to a judge, and sometimes it can get very complicated. If you look at the Tribunal for Lebanon, for example, the Special Tribunal for Lebanon, they had to develop groundbreaking technology, I guess, and then be able to explain that technology because all their case, or the vast majority of the case, was based on phone records and different types of phone records, cellular phone records and information. Very interesting. So yeah, we went from a witness base to a multimedia, if that's the term, case, where all sorts of information and all types of information from different types of sources can and is being used.
Has it strengthened the case making?
Yeah, I think it does to a large extent. First of all, victims will always be centered to everything and should always be centered to all of these proceedings. They are the center of this. So you will always have witness testimonies for not only to prove your case, but to have a legitimate case and a legitimate judgment. But it has opened up possibilities of proving events in a lot of different ways that we did not have. So if used properly, yes, it can, I would say, not necessarily strengthen the case, but certainly give it a lot more breadth and depict a much broader narrative that in and of itself maybe even gives the judgment more, if not legitimacy, at least potentially more impact.
Thank you very much, Robert Petit. Thank you for sharing your experiences, and wish you much success with the IIIM work.
Thank you very much.
A postscript. This conversation took place in November of 2024. On December 8, 2024, the Assad regime collapsed. Since then, the IIIM has much greater possibility to access information and interact with civil society that has begun to collect abandoned documentation from prisons and prisoner testimonies. However, Up to the date of publication of the podcast in late October 2025, only Robert Petit, as the head of IIIM, was allowed to visit Syria. The mechanism's team has not yet been granted permission to collect data on its own in-country.